Welcome to The Explainer. Today, we're cracking open a powerful four-step framework that experts use to solve their toughest problems and build arguments that are practically unshakable. So let's just start with a situation we've all been in, right? You're faced with a complicated problem. It could be at work, maybe in a negotiation, or just trying to make a big life decision. Things feel messy, and the path forward is anything but clear. But what if I told you there's a simple, four-step mental model that can cut right through all that chaos? A way to structure your thinking that helps you see things clearly and make a much more persuasive case for your ideas.
It's called the IRAC method. That stands for issue, rule, application, and conclusion. And here's the really cool part. In this explainer, we're not just going to learn about IRAC, we're going to use the IRAC framework itself to explain how it all works. Let's see it in action.
Okay, so let's put this thing to the test. To really see how IRAC works, we're going to apply it to a real-world example. And for that, we'll borrow some material from a business law course.
The very first step in our framework is I, for issue. And this is all about one thing, getting right to the heart of the matter. You have to clearly, sharply define the central question you're trying to answer. No fuzziness allowed.
So to stick with our own method, the issue we're going to tackle is this. How does a legal contract actually end? How is it officially discharged? That's our question. Next up, we've got R for rule. See, once you know your issue, you need to gather the rules, the laws, the core principles, whatever they are, that govern that issue. This is basically you assembling your toolkit for the job. In this slide right here, this is our complete toolkit. According to the legal principles, there are 5 key ways a contract can be discharged. Now, don't worry, this isn't going to be a law lecture. We're just going to quickly look at what these are so we understand the rule step. First, and honestly the simplest, is performance. A contract ends when everybody does exactly what they promised to do. The deal is done. Easy enough, right?
And the law has always been super strict on this point. There's a famous case from way back in 1795 that established this idea that performance can't just be close enough, it has to be exact. Second way is by agreement. This is pretty much what it sounds like. The people involved can just mutually decide to walk away from the deal. They shake hands and call the whole thing off. Our third rule is called frustration. This covers those totally unforeseeable events, an act of God kind of thing, that makes it genuinely, physically impossible for either side to do what they promised. Okay, next is breach. Now this is a really important one. A small mistake or failure doesn't automatically kill a contract. The screw-up has to be a major one to give the other person the right to just terminate the whole deal. And our final rule is operation of law. In this case, some big external legal event, like a company going bankrupt, can just swoop in and terminate a contract automatically, no matter what the people involved actually wanted. So that brings us to A for application. And honestly, this is where the magic really happens. You take all those rules we just gathered and you apply them to the facts of your situation. This is the analysis part, where you connect the dots. And this slide is a perfect illustration of why that application step is so critical. If we're looking at a breach of contract, we have to ask, was it major or was it minor? Because look at the difference. A major breach lets you end the contract. A minor one doesn't. The analysis completely changes the outcome. And finally, we arrive at C for conclusion. After all that work, identifying the issue, understanding the rules, and applying them to the facts, we can now draw a clear, logical, and really solid conclusion. So, for our little case study, the conclusion is simple but pretty powerful. Contracts don't just fade away. They are terminated by very specific, defined events that tick one of the boxes of those legal rules we looked at. But let's be real, the main takeaway here isn't about contract law. It's about how powerful this framework is for organizing your own thinking in any complex situation. By forcing you to state the rules before you apply them, IRAC stops you from jumping to a conclusion based on just a gut feeling. It's a structured process that helps filter out bias and make sure your logic is sound from beginning to end. Think about what we just did. We used this exact 4-step structure to analyze a legal problem from start to finish. And you can use this same process to tackle challenges in business, in strategy, or heck, even in your personal life. At the end of the day, the IRAC framework isn't just some dusty tool for lawyers. It's a blueprint for clearer thinking. It gives you a reliable path through any kind of complexity. So the only question left is, what problem are you going to solve first?